Welcome to episode 6 of Think at Heart. We're super excited today. We've brought in an expert. We figured people were probably tired to listen to Ben and I talk about the market. We actually premiered Think at Heart with an interview with the one, the only Tom Deans talking about estate planning and wills with promoting his book, The Willing Wisdom. And which was amazing, and that really focuses on the communication within the family. But one thing we definitely wanted to get to was, the practical implications of those types of things. Okay, that's great. I'm going to sit down, have that family plan, but now what do I do? What do I have to focus on? How do I actually build this will? Who do I contact in order to do those things? So we searched far and wide. We asked around, we searched our network, and people just keep telling us about this one person, right? Man, you got to talk to Jessica. You have to talk to Jessica. So we pulled some strings and we got from JH Legal Services, Jessica Houle, who focuses on employment and estate planning. She has a boutique firm. Yeah, she has a boutique firm here. So without further ado, I will turn it over to Jessica. Welcome.
Thank you.
And maybe you can start by number one. I always forget this, so let's just start telling us what your website is, your email, social media, however people can contact you if they need to.
Of course. So thanks for having me. It's a pleasure to be here. And as Scott said, I am an estate planning lawyer and an employment lawyer. And the best way to reach me is through email and through my website. So my website is jhoulelaw@jhoulelaw.com. And there's a way to contact me there through the contact page. And my email address is jhoule@jhoulelaw.com. You can also find me on LinkedIn. You can find me on Twitter, and you can also find me on Instagram.
Amazing. And we'll link all those things in all the descriptions as well on the podcast and on YouTube. All right. Well, I know Ben sent you a list of 1,274 questions. So we better kick. Yeah, one at a time. Okay. 1A, Ben. All right, Ben, why don't you start by telling us a little bit about your thoughts here on what the setup here should be, and as far as, what do you see as far from our client standpoint, what do you think they're missing as far as their estate planning and wills and whatnot?
Yeah, so we get tons of questions all the time. Certainly after we had Tom Deans on, we got lots of questions about where do I start, what do I do? So I want to maybe paint a little picture, maybe I'd like maybe a little bit of background on who you are as well, why you got into law, maybe tell me a little bit about yourself first, and then we can jump into really talk about a lot of the questions that clients have, and hopefully maybe kick off a few of those things and really provide some good guidance and really kind of set the stage for what we're going to go through. And clients get lots of questions about cottage transitions and what's a will look like and how do I set up a trust, and it's a really overwhelming thing. So hopefully we can get through as much of that today as we can. So maybe you can start me off with, who are you? Where'd you come from? Why'd you get interested in the business?
Straight out of North Bay.
Yes, sir. You got that right. Yeah. So Northern gal. I am originally from North Bay, where I grew up there with my parents and both my brothers. And grew up there. My parents moved us to Orleans when I was just finishing my last year of high school. And after that, I took a year off to travel the States. I was a figure skater with Disney on Ice for that year. And then when I got back, I went to University of Ottawa. I was studying in psychology and philosophy, and then I got really interested into law, decided to apply and got in. And so I started with civil law, which is a legal system that applies to Quebec in Canada. And then I transitioned into the common law section at the University of Ottawa. And then common law is the law that applies to the rest of the province and provinces in Canada. So I do have dual degrees. And I am practicing in Ontario. I do not practice in Quebec, but yeah, here I am, 10 years in, and I practice at the same law firm for 10 years, doing mostly wills and powers of attorney, estate planning, and then branched into employment law. And these two really, really interesting areas of law that have no connection whatsoever.
Yeah.
A very strange mix of law practice, but they both have a really, simple common denominator, which is organization at its core. And organization is my passion. So I spend my days talking to people and organizing their lives and their businesses. And it's what I love to do.
Awesome.
It's amazing.
Awesome.
Before we get going, I'd just like to point out that you and Ben have a very similar background, because he also worked for Disney. He also worked for Disney.
Did you say?
Yeah, actually, I'm from Sudbury, and I worked at Disney in Orlando. That's where I met my wife. And at Disney,
Yeah, that's cool.
Yeah, exactly.
So very similar career paths you guys have. They're pretty much identical. It must be those, Northern Ontario ends,
exactly.
right?
Yeah. Northern side.
Except I'd say my organization skills, I'm sure, aren't the same.
I agree. I can back that up.
Exactly. Well, that's awesome. Good for you. So that's great. So we'll definitely talk a lot, mostly about estate planning today. Certainly, employment law, I think you've probably been busy this year. I mean, there's lots going on. Yeah.
Very busy. Yeah, areas this year. Mm-hmm.
Yeah, for sure. So I've had lots of clients ask about that too, is, they start to get concerned about what's going to happen and making sure their wills and things are updated. But, I thought, I have really kind of, and I think we talked a little bit about, you got multi-generations, my kind of deepest relationships would be 4 generations. Mm-hmm. And so, you got kind of levels of conversations with 20-year-olds, with 45-year-olds, with 65-year-olds, with 85-year-olds, and each of those levels I think are probably different. So I guess as I look at it, I think about them separately. And would you deal with all through that spectrum as well, or where would kind of be the most of the contacts you'd have?
Yeah, so all over the place. My clientele ranges from, young people, not married, no family, to, the elderly who have a lot of, family history and background and a lot more things to consider. But it's a really interesting point that you bring up, because it's this huge misconception. People think that, you have to be old to do a will, or to look into it, or to wait. People say, well, I'm way too young to think about that, or I don't have a lot of assets, or I don't, just a lot of things that people think. And it's a huge misconception, because in my opinion, everybody of age should have a will, and for different reasons. So I'll start with, the younger, what are the reasons that I would give a young couple, for example, or a new family, the reasons why it's important to have a will, or to start thinking about that planning process. So the first thing that is important to consider is your children. So what's going to happen to your kids if something happens to you? Who's going to take care of them? Who's going to take care of their assets? Where's the money going to go? Who's going to manage it? Is it going to be in a bank account? Is it going to be in a trust account? Which family member is going to have access to those funds? Where are my kids going to live? Like all these things.
Yeah.
And it doesn't matter how much money you have. At the end of the day, if you have children, you need a will. If it's for the sole purpose of determining who is going to be the guardian of your kids and their assets. The other thing that a lot of people don't know is if you don't have a will, so people might say sometimes, well, it's a no-brainer. I only have one brother or one sister, and if something happens to me, everybody knows that they're going to take my kids. We've talked about it, they've agreed to it, and
Yes.
but if there's no will in place, to say, who's the guardian going to be or who's going to take care of their assets, the money that would go to them is going to be paid into court until the child attains the age of 18. And when they turn 18, they get the bulk of that money. So no matter what the amount is. So some people might say, I don't know about you, but I find that 18 is quite young to
for sure.
manage large sums of money. A lot of people are either still in school or trying to figure out what they want to do with their life or what they want to study, where. And if they come into a large sum of money, that might have an impact on their decision for the future. So that is a really important point. Young families need to consider not just the guardianship, naming, but the trust component, of making sure that the money is going to be managed by someone that you trust, and that the family has access to it to take care of your children.
Sure. So give me a scenario. I guess you have. Maybe I think about it in a couple parts. So maybe I'll start with the first one and then I'll get to the second one. My first question would be is you got a 30-year-old couple that have a couple of kids and they want to put a will in place. They haven't done it. Maybe tell me what that process is like with you and with most lawyers, and what would they do? Where would they start with that?
Of course. So every lawyer is different. Every lawyer has their typical process on how they like to do this. And definitely the last year has been different for everybody because we've had to do a lot of this virtually. But typically, COVID aside, the first step, the clients would communicate with me through website, telephone, email. First contact, we would book a meeting. We would meet in person. We would talk about their situation, their background, their finances, just to get a global picture of the and the family portrait, the family dynamics. And then I would work on their documents, send it to them by email. They would review it. And then once everything has been approved, we then book another meeting for signatures. So final review and signatures at that point.
Sorry, keep going.
Go ahead.
Yeah, so what's the toughest part typically about that for somebody like that? What's the thing where they sit on this and they spend like days and weeks and a long time thinking about what's the toughest part?
So I think the toughest part is actually getting started.
Okay.
So I do this two ways, and it really depends on the type, it really depends on the client. I will explain to the client that we can do it in a couple of ways, and then they choose whatever they feel most comfortable with. But so we can do like an initial video conference or teleconference, and then the client, I send a questionnaire via email to the client, which they would fill out, whenever they have time, and then get back to me. that is where people procrastinate.
Yeah,
Because
exactly.
they get the questionnaire and then they'll sit on it, and then they'll start to think about all these things, and then they just say, okay, I'll do this tomorrow, I'll do it over the weekend, I'll do it next week, and then things just don't get done. Things just don't progress. So the way that I prefer to do it is I prefer to meet in person, get all the information that I need, be able to have those discussions, those, sometimes hard or difficult discussions in person, comment, provide advice, all in the same, all at the same time. And sometimes I act as, the mediator between spouses who haven't really taken the time to discuss a certain, maybe, a difficult point. Or who's going to take care of the children, or who's going to benefit if they all pass away at the same time, or things like that. So I am a strong believer in open communication. So I prefer to work that way, but I will definitely adapt my ways to the client's preferences, for sure.
So, so I've found that guardianship one, they oftentimes the couples don't seem to, they just think, well, my parents will take them, or my parents will take them. Mm-hmm. So what would happen though if something happened? What's the default? Because you mentioned before, if you don't have a will in place, then everything goes to the court. So what happens if something happens to young parents?
Yeah. So even if you do, so if you do have a will, and even if you do name a guardian for your children in your will, you don't create a legal guardianship relationship just because you named that person in the will. It's like a declaration of your wishes and intentions. Like, if something happens to me, this is who I want to take care of my children. Okay. And that person actually needs to make an application to the court within 90 days to apply for legal guardianship of your kids. So what the will does is it tells everybody, right, this is the person that we've chosen to take care of our kids because we trust them. And for whatever reason, it's no one else's business but yours. This is who we choose. If you don't have a will, then the family, the friends, they're going to choose for you. And the person who's going to end up making that, application for guardianship for your kids might not be the person that you would have chosen. Sure. So at the end of the day, that might mean you have a sibling who lives in Vancouver who decides, that they're the best person to take care of your children, which means that your children may have to move. Or change schools, or change, you're taking them away from their circle of friends, their circle of, things that they're comfortable and used to. So while kids are already grieving, you want to make sure that you create a stable environment for them as much as possible. Yeah. By making sure that you put things in place to comfort them. If something happens to you, you don't want things to be all over the place. You don't want people arguing about who gets the kids, who gets their things, who takes care of them. Yeah. And court applications, let's be honest, they can be expensive, and there could be some delays, there can be some additional costs. So it's always best to put that in writing.
So if you don't, yeah, for sure. And if you don't, just so I understand, like if you're, there's no will, the court picks a guardian, does the court also assign if there's a residual estate to the guardian, or the court decides that independently? Do you know what I mean?
So you mean like with regards to the assets?
Yeah.
So yes. So if you don't have a will, and so guardianship aside, and just, yeah. I just want to point out that the court will always make a decision that's in the best interest of the child.
Sure.
Okay. So guardianship aside, what happens if you don't have a will in general? So in Ontario, if you don't have a will and you pass away, If you are married, and I say married because common law spouses are not considered spouses in the estate world. So if you're married, no children, your spouse gets the bulk of your estate. Okay.
Yep.
If you're married with children, in Ontario, there's a preferential share of 200,000. So your spouse gets the first 200,000, and then the rest of the estate would be distributed between the spouse and the children.
Gotcha.
If you pass away, no spouse, no children, then it goes back up to the parents. And then there's no parents, then it goes down the bloodline. So aunts and uncles, cousins, grandparents. Yeah. So it really, the law basically chooses who will inherit, as opposed to you having that, freedom to choose.
Sure. Is Quebec the same you mentioned the part of a common law spouse isn't deemed a spouse for estate purposes in Ontario? Is it the same in Quebec, or do you know?
I'm not going to comment on the laws in Quebec. There are quite a bit of differences, and I don't want to put my mouth. I also don't want to express any personal opinions. So,
Gotcha.
Yeah.
No problem. That's a question for another day. Because I've had that question specifically, so we'll leave that for another time. But yeah, I know it is. I'm sure that the younger people are probably the hardest to get to that point, because I think once the will's in place, then people, I guess, want to look at it again at some point, and they understand they got to change it. But I also start to have the conversation with now that the kids are in their 20s. We are, in our, we'll call it 50s, 60s. We haven't changed our will since the kids were born. What would they do now? Would they, often they say, do I go back to my lawyer? Where do I go? What would be a suggestion for that group?
I think it depends on the client's level of comfort. If there's an established relationship with their existing lawyer, I would definitely suggest that they reach out to their existing lawyer to see, to talk about, the steps of updating their will, which is super important. Most people, it's hard to get them to actually do a will, and then they do one, and then they think, okay, I've done it. That's it. I'm putting it away, and I don't have to touch it again. But life changes, people change, circumstances change. So you need to keep it updated. Absolutely. And it's not necessary for the client to communicate with their existing lawyer. They can reach out to any lawyer, because a new will would automatically revoke the previous will. It's one of the first things that we mention in a new will. So especially if the will is dated 10 years plus or whatever, it's a whole new will at that point. So
So how often do you think people should revisit their wills?
That's a good question, Scott. And I get that question from every single client. So I tell my clients, don't base yourself on what you hear online or, from other people saying, okay, every 5 years or every 10 years. It really depends on your circumstances. So I tell my clients, pick a date. Usually I tell them to pick the date that we sign their wills. And I'll say every year on that day, sit down, reread your will if you haven't done it, through the year, and ask yourself the question, if I die tomorrow, is this still what I want? Does this still reflect my wishes and my intentions? If the answer is yes, then put your will away until next year, or until your circumstances change within that year. And if the answer is no, then that's when you contact your lawyer and you say, you know, here's what's going on in my life, or here's what's going on in my mind. Does it, you know, is it worth making a change to my will? And then we would have that chat and we would determine if we make a change.
That's great.
Yeah, that's a good point. And I mean, I think that the majority of people, I mean, your client base might be unique because you've kind of taught them to think that way. But the majority of clients I talk to, like they rarely look at their will until we're near the end.
Yeah. No, I definitely make it a point to review it at least once a year. And also every time something changes in your life, a major change, you have another child, you lose a child, you lose a parent, you lose someone who's named as executor or beneficiary in your will, you got married, you got separated, you got divorced. Any of those, you know, major events in your life might not necessarily mean that you need to change your will, but is definitely worth a chat with your lawyer to determine if a change is necessary in your circumstances. I give my clients a Christmas ornament that says, so that they think of me every Christmas, and I will, and it says on it, have you reviewed your will this year? So it's kind of like a little reminder to to reread it and just make sure that it's still what you want.
So do you think I think people read their wills too and they're like, I don't want to go through I should make this change, but I don't have to call the lawyer and then have to deal with them, and I got to go in there, sit there, and they're going to tell me all this stuff, and they just want to make the change themselves on the will.
Yeah.
What effect does that have on the will if they try to make changes themselves?
It could have a devastating effect if it's not done properly. Any client of mine that you speak to will tell you that I've probably told them several times that I do not like handwritten notes on the wills or notes in the margins or an additional paper that says, oh, I just want to change this, or I just want to add this, or I don't like codicils. I like clean documents. No paper trail of I've changed my mind and it wasn't done, through a proper process. And so everyone can change their mind. And holograph wills, which are wills that, people can do on their own without going through a lawyer. It's legal. It can be valid if it's done properly. I don't like them. And my fear is with these handwritten notes is that if it's not done properly, the effect that it can have is to completely revoke the initial will, or let's call it the first good will that the person has made. Because you do have to confirm that the rest of the terms of the will are still valid and that they don't change, and that you're not revoking the will, you're just, adding to it. So it's very tricky, and you just have to make sure that you do it properly. And for me, these handwritten notes is what creates confusion in the family, tension in the family. Especially if that note is not, it's not legally done right. But, they'll say, the family will say, yeah, but it was still mom's intentions, to do it this way, or it was still dad's intention to give me this. That's when things get really messy. So my advice to people who just want to change a little thing, is to still go through proper channels, communicate with a lawyer, shop around. You don't need to be afraid of talking to different lawyers to see what their pricing is, what their process is. Yeah. So.
Yeah. So, in Tom Dean's, when he talks about the family meeting, is that something that that you speak with clients about as well? And do you have a family meeting where you discuss these things as well?
So with clients, I don't typically do family meetings. I've done a few at the request of some clients, and you kind of just act as a facilitator to open the communication and kind of give everybody an opportunity to express themselves.
Yeah.
But like I mentioned earlier, I am a huge believer in open communication, and so family meetings and family discussions, although very uncomfortable sometimes, in this area is necessary, and to make sure that your wishes and intentions are clearly communicated is important.
Yeah, for sure. Well, the majority of conversations that I have with clients would be the older ones. And that's where they start to think about the fact that they're actually going to die. And so, those tend to be the more complicated conversations too, where, clients are in their 80s, they got different, kids that are grown up now and they have grandkids, and, a lot of them too are kind of stuck to their old wills, right? They don't want to start again. So, those are a challenging time. Also, we've talked kind of mostly about wills, so maybe you can talk a little bit about, how important the power of attorneys are for finance and for continuing care, like maybe what that means, what that gives people the ability to have control of, and maybe give me a little bit of that.
Yeah. So powers of attorney are just as important, if not more, than the will. So to give a quick explanation, so a power of attorney is a document that allows someone else to make decisions on your behalf in case you become incapable of making those decisions on your own. So in Ontario, there are two main powers of attorney. There's a power of attorney for your health, and there's a power of attorney for your property. So the power of attorney for healthcare, you would name somebody that you trust to make decisions on your behalf with regards to your care. So whether that means who's going to decide what medications you take, what procedures you're willing to accept, where you're, whether or not we pull the plug if worse comes to worse. That document is so important in order to facilitate the process for everyone, the family, the medical team, everybody. And the power of attorney for property is the document that allows someone else to manage your property on your behalf if you become incapable of doing it yourself. Managing your accounts, managing your investments, managing your property, paying your bills, making sure everything is paid on time. So these documents are extremely important, because if you don't have them in place, the province doesn't assume who you would have named. Like a lot of couples will say to me, well, I don't need powers of attorney, we're married. So, if something happens to me, like my husband is just going to make all those decisions, or my partner is just going to make all those decisions on my behalf. It doesn't necessarily work like that. So even though you are married to someone, it doesn't necessarily mean that they're the person you would have chosen to make those decisions on your behalf. So if you don't have a power of attorney, then we have to apply to the court to have somebody named as your guardian or the guardian of your property. And it's a process, and it can be expensive. So, and it's also a very stressful, or can be very stressful if decisions need to be made on, on an emergency basis, or things just need to get done.
For sure. Yeah. Yeah, that's the one I would see most of, is the power of attorneys, and with the older clients to get, oftentimes they're chicken scratch, like old things that they had 40 years ago. They're definitely important, and the firms are getting more and more specific about what the forms say. So that's definitely very important.
Yeah, absolutely. And some people will also think that because they signed a direction at their bank, like allowing somebody to, handle that account for them if something happens to them, that's not a general power of attorney. It's, it's a limited power of attorney with regards to that specific account at that specific bank. So it doesn't allow that person to manage everything in general. So it's important for people to understand that, and just to know that powers of attorney just facilitate so much, of the processes for everyone again.
Yeah. Well, and this clientele maybe just extend a bit, because they would have, I get lots of the older clients that have, maybe a house in Florida. They may have a property in Quebec. They may own a corporation as well. For somebody like that, do they have one will? Do they have multiple wills? Like, what's typical?
Okay, so I believe in a collaborative approach to estate planning. I think that the biggest mistake that professionals can make is not knowing what their limits are, not knowing or not wanting to seek advice from the experts, because we're not experts in everything. We might be very specialized in our respective fields, but it's important to recognize when, you need to get that advice from someone else, whether it's an accountant, a financial planner, a foreign advisor, anything. So for me, and this happens often because we have clients here in Ontario. We have a lot of people who have properties just on the other side of the river. And it is two separate legal systems. So in Ontario, we have the common law, and then in Quebec, we have civil law. So it's important for clients who have property in Quebec to have a will in Quebec and to have a will in Ontario.
Okay.
I will comment on this specifically, only because there's so many clients that are in that situation. And a lot of times people will say, well, that's really annoying. Like, I need to do a will in Ontario, and now I need to talk to a will in Quebec and start the whole story again and pay, the same fees or whatever, close to, just to have a will to deal with my cottage that's in Quebec. But it will reduce not just fees, but time and stress and process if something happens to you. So I always advise clients, let's do your will here in Ontario. I will refer you to someone who specializes in wills in Quebec, a notary that I feel comfortable referring, or if they already deal with somebody, then that's perfect. We'll reach out to them. They will do what we call a Quebec will, and then we will make sure in the wills that we don't revoke the respective wills. So that's why it's important to have these conversations with your advisors, because you do a will in Ontario, you'll say, okay, I'll just go do a will by myself in Quebec, without speaking to a notary or whatever. And then you inadvertently revoke the will that we did in Ontario, and then the whole process just becomes, pointless. So it's really important to to not only mention that you have property outside of Ontario, but to make sure that you talk to the correct people. And if I have clients who have assets in the States, Florida, wherever, my advice is always to have a will where you have property. It facilitates very, very, much the executor's responsibilities upon death. It means there's a will in, let's say you have property in Florida, there's a will in Florida that will allow us to deal with the property there. There's a will here that will allow us to start dealing with the assets here right away. And in Quebec, same thing. So there's no delay. We're not waiting on any documents from any other province or state or country in order to start dealing with the assets here.
Yeah. So do you always reference then, I guess, this would be kind of the core will, and then you'd make reference to the other wills? Is that what you're saying?
So it depends on which will is done first. So if I'm the first will to be done, then the other wills, I will suggest, reference to this one and say, I revoke all previous will except for except for my Ontario will, or except for, my Florida will, or whatever. Yeah. It's important to have that mentioned though.
And just in addition to that, just to complete the loop on it, corporations, if you own a corporation, you have a separate will, or do you include it in the core will?
Yeah, so if the answer is a typical lawyer answer is it depends. So it really depends on the circumstances of the client and the client's preference or decision. But there's a possibility in Ontario to have two wills. So a primary will that will deal with your general estate, and then a secondary will, which will deal with some limited property, such as corporate assets, or if somebody has a significant amount of personal property, we can include in a separate will as well. The idea behind having two wills is to limit the amount of probate fees payable upon death. So we would put in a secondary will assets that don't necessarily require probate in order to transfer. And then in the primary will, we would put, the general estate and general things that may require probate.
So what wouldn't require probate for? Just like, obviously the corporate assets don't require probate. What are some of the
they do if they're not in a they do,
if they're not in the secondary will?
Yeah. So things that would require probate would be assets that you own in your name only. For example, if you own a house that's in your name only and you pass away, the land registry is not going to let us deal with that property unless we obtain the certificate of probate. So we need to have that property evaluated, and then we need to calculate the probate fees. Yeah, and pay them to the Ministry of Finance and so on and so forth. Other assets would be, for example, if you have life insurance or any other, registered RSPs, TFSA, that you haven't named a specific beneficiary. For example, if you've named the estate as the beneficiary, or if you haven't named a beneficiary, then that asset would fall and form part of the estate, and we would need to calculate and pay probate taxes on that amount.
Yep. And that's great. So, and then everything else so that secondary will sounds pretty key if you have a corporation.
If you have a corporation, absolutely. And like I mentioned earlier, we talk a lot about these secondary wills being for corporations, and they are. But if you have a significant amount or valuable personal property, art collections, jewelry, collectibles, whatever it is, it becomes very interesting also to have those assets into having them mentioned in a secondary will to protect them from probate as well.
Okay, interesting. Yeah. Other thing I wanted to have you just comment on a bit. I know a couple of years ago, rules got changed for executors' liability, and so executors now are legally liable for their mistakes. So maybe give me some context and some thinking around that. What's that done? I know executors can get executor insurance now, so that kind of business has changed. But how much has that changed that dynamic about who the executor should be?
Yeah, so it's a very interesting comment, because choosing your executor is such an important piece of estate planning. You really need to think about who's the right person to handle these affairs once you pass away. Being an executor nowadays is not a simple task. There's a lot of responsibilities. There's a lot of things to accomplish, and executors can be personally liable for their mistakes or their decisions if it's proven that it was either done in negligence or in bad faith or fraudulently or anything like that. So yeah, it's important to name somebody that has good, or that is good with managing their affairs, good with managing their money. And that's going to be able to take on this role on behalf of the family. You mentioned Executors Insurance. That is something that I also mentioned to my clients. There is a specific clause that we can incorporate in wills that allows executors to obtain insurance at the expense of the estate. Some clients like that, some clients don't. It all depends. But yeah, it's a question I'm asked all the time, whether or not an estate executor is responsible for the testator's debts, and so if they're responsible for any other decisions that they make throughout the process.
Sure. So maybe just clarify, does an executor get paid? How do they get paid? How do people decide that? Does the executor decide that? Who makes the choice? Maybe talk a little bit about that.
Mm-hmm. So in the will, we can definitely clarify and say that the executor gets paid a certain amount or a certain percentage, or or they get a percentage of the estate, for example. But if the will is silent, then the law provides that the estate executors can be compensated for their role as estate executor. And then in the will, what I usually do is I just I say that the executor is entitled to reimbursement of all their expenses, first of all. Sure. And then they can be compensated in accordance with rules and regulations at the time. And so there's like a general it's not written in the law, but there's a general understanding that executors will receive between 2.5 and 5% of the value of the assets that they deal with. So they do require the approval from the beneficiaries, and if the beneficiaries don't agree, then the estate executor would make an application to the court to have the court weigh in on the amount of compensation.
Sure.
Can you hire like a professional executor, or like it would be somebody like you? Because I think most people just pick, I'm going to pick my oldest kid to be the executor of my will. Right? Yeah. And they either don't want it or don't have the skill set to do that. Right. What are some of the options for people to do that?
Yeah. So third-party executors, and when I say third party, I mean like somebody who's not necessarily part of the immediate family, is important to consider when it's not just about how much money you have. Again, it's about family dynamics as well. If you have children who don't speak to each other, or are estranged or whatever. It could be, you know, a really tough time for grieving families to have to now forcefully deal with each other to administer this estate. So sometimes you name a close family friend, someone who, you know, can be objective in the situation, and a family friend, obviously, that you would trust and who is able and capable of managing affairs. You can name, it could be an advisor, if that advisor is willing to act as a state executor. So I think, Ben, we had quickly mentioned during another conversation. So do lawyers act as estate executors? So lawyers can act as estate executors. It all depends on the lawyer's willingness or comfort level to do so. We do it as professionals. We don't do it as actual trustees. So it's the lawyer needs to decide whether or not they want to take on that role personally, professionally. So have I done it before? I've accepted on behalf of clients, you know, to act as their estate executor in very limited cases. It's not something, it's not something that I do all the time. There are lawyers who offer their services as estate executors. There are trust companies that offer their services as estate executors. All major banks normally do offer these trust executor services. So you would name them, these trust companies, in your will as your executor, and upon death you have this professional team. Yes, there are fees involved, but this is what they do. And this, they know how to manage, they know how to handle families in the process. They've done it hundreds of times. So normally it just can facilitate the process and just get things moving quicker.
That's great. Yeah. So maybe just a quick definition between an executor and a trustee. You know, sometimes people use that interchangeably, and I know they're not always the same thing. Maybe just sometimes they are, but sometimes they're not.
Yeah. So normally in a will, we'll refer to my executor and trustee. So we'll name somebody as the executor and as the trustee at the same time. So the executor is the person who is going to administer the estate, handle the estate, manage the affairs of the estate. And then a trustee is someone who is named to manage property for the benefit of somebody else. So you might name somebody as an estate executor to handle the estate, but you would name somebody, a different person, to act as a trustee for the trust of your kids. You know, it doesn't necessarily need to be one and the same, but I'd have like 98% of the time, people will name the same person as executor and trustee.
Yeah. Okay. Yeah. Okay. Just in regards to, I guess, the trusts within a will. So is this a separate document, or is the will just name a trust, or do you have like, how does this play out? Like, you set up a trust for your kids, hypothetically. Is it part of the will, or is it something else?
That's a loaded question. And I will answer it, you know, as simply as I can, because there can be some standalone trusts. And then there are some testamentary trusts. So a testamentary trust is a trust that is formed in the will, and that only takes life upon the death of the testator. So this trust is created through the will. Once the person dies, then the trust is created. And then there are some standalone trusts that you can create during your lifetime that are separate from the will. You can do spousal trusts. You can do alter ego trusts. You can do Henson Trust. All these different types of trusts, which we're not going to dive into because that's a conversation for another day. Yeah. But yes, there's definitely different ways of creating trusts, and it again all depends on the client's circumstance. Yeah.
For example, if you name a simple testamentary trust, in the will you would name who the trustees are as well. Like that would be part of the package. Yeah.
Typical example, you have parents with young children who would like to create a trust so that the kids don't necessarily inherit the bulk of the estate at the age of 18. So this happens all in most parents' wills. We'll create a trust within the will that dictates when the kids would get a certain percentage of the money at certain ages, whether it's 25% at 18, 25% at 21, and the balance at 25, or 25% at 25 and the balance at 30. We can be very creative, but that's an example of a trust that we would create through the will.
Yeah, awesome. What do you think of informal trusts that are set up at institutions, financial institutions? There's lots of informal trusts. What do you think of those? And ultimately those should go to the kids, I guess, at 18 anyways. So sometimes I have clients that want to set up a informal trust just so they can kind of in their mind have some money set aside to them. And so what do you think of that?
I have to say I don't have much experience with informal trusts. I'd have to get a little bit more information from you with regards to that.
No problem.
But I don't have an issue with separate trusts as long as the parents keep reviewing the terms of that trust and making sure that the terms are they don't confuse with whatever the will might say, or
So I do have another question about trust, because I do sell life insurance as well. So we are life insurance licensed. Can you name trust as the beneficiary of an insurance? Do you know? Have you seen that? So for example, you'd set up, maybe you have a Henson Trust for a client because a client has a disabled child. That occasionally you would potentially name the trust as the insurance beneficiary. Have you seen that or anything?
So again, every financial institution has its internal process, and they'll tell the client whether or not they can name a trust, or what's the best way to make sure that monies flow through a trust in order for those funds to be protected, especially if you have a child with a disability, or a sibling, or a spouse, or a parent that you're gifting to in your will. I think the most important thing is to always make sure in your will, if one of the first things that I do with clients is I make sure that they've designated beneficiaries on all those registered policies. So I want to see their life insurance. I want to see who they've named. I want to make sure that it reflects their wishes and intentions. I want to make sure that if it says the estate is the beneficiary, that they're okay after I've explained to them what that means. What's going to happen upon death. I want to make sure that they're comfortable with that. If you have a life insurance policy and you name the estate as the beneficiary, you have a disabled child, and in your will, we've created a Henson Trust. It's going to be important to identify that life insurance policy and make sure that it doesn't go directly to the child to affect their benefits that they're receiving from the government, and just make sure that that money flows through the proper channel.
So say it's set up by, like, say inadvertently it gets set up for as the estate, the life insurance, but there is a Henson Trust. Can it go there without being probated?
Well, no, it would have to be,
Have
yeah,
to be probated.
yeah.
Got it.
So, and the other thing is what's dangerous about that scenario is that it might have the effect of, sorry,
Yeah, potentially kicking out some of the benefits for the child.
exactly,
Yeah, yeah,
like disrupting those benefits, and then you have to deplete that child's assets until you're able to apply again, and
sure.
just a mess. Mhm.
Yeah, for sure, for sure.
Mhm.
Yeah. So I just thought these questions are coming to me as you're talking to me. Just as you have all these conversations with clients over the years, you just kind of these little things start to pop up as we talk about it.
Yeah.
So I definitely I still got a few questions I'll look at, but yeah, I think we've hit a lot. Scott, do you have anything that's popped up as we've gone along through here?
I learned more in the first 15 minutes than I knew before I came here, like for my entire life. So yeah, I mean, the biggest thing I've realized is that it's so detailed. There's so much to know. I mean, you even met a few things that you've just skimmed over that we could probably do an entire episode on, right? That'd be super important.
Yeah.
Which is a great idea, by the way. I think we should do that. But yeah, I mean, there's just so much to know, and the importance of using the experts, right? Going to the right people, because I know from the people that I talk to, the very few people that do have wills, some of them just, they get the will kit, they jot something down themselves, and we know that's not binding in most cases, right? But just knowing all these things is so important that it will just save so much time and anguish too at the time when people are going to be stressed when that time comes. So
Yeah.
I don't know that I have any additional questions. I'm sure I know you do, Ben, but I'm just absorbing.
That's good. That's good.
I know I haven't had one episode where I've been this quiet.
Yeah, exactly.
It's crazy.
There's lots to cover. Yeah, I think I get all the time. I get questions about when should I review the will, when should I change it, when should I update it. Oftentimes too, we get lots of people talking about it, putting a codicil on my will, and they end up having all of these other pieces to it.
Mm-hmm.
And so I assume at some point it makes sense to just blow it up and start again.
Yeah. So for me, I like clean planning, organized planning, one document if possible to deal with all of the intentions, not 3-4 codicils on top of a will. It's just nice to have a streamlined, clear document that deals with everything. And just to go back, Scott, you mentioned something about what did you say? You
The
said
will kit.
Yeah, the will
from
kits.
Staples. They sell it right at the cash.
So many people think that their situations are simple, and most clients that will call me and say my situation is so simple end up being some of my most complicated estate planning files, because you may think that your situation is very simple, but when we get talking and when we dig into the family portrait, the family dynamics, the finances, the blended families, it might be simple for you, your life might be simple for you, but legally speaking, there might be a lot of things that you need to consider that you're missing. So that's why I'm a strong believer in a personalized approach. And this is why I think clients need to reach out to professionals in order to have these discussions to determine what they need, instead of self-assessing and thinking that will kits are fine. So it's not, estate planning is not one size fits all. It really is and needs to be tailored to your specific circumstances. So that's what I have to say about will kits.
And so just about, I guess, a little bit about, I know it's different with every person, but sometimes clients get concerned about, I'm going to spend 15 hours with a lawyer. I'm going to pay them 15 hours to do this. What's that process like? And would you offer something where I'm doing a will for you and it's going to be approximately this much, or is everything, is there a typical timeline? Maybe a few details on that.
Yeah, of course. So process and pricing, it's one of the first things that I address with clients. I know that it's a burning question that they cannot wait to ask me.
Yeah.
I give them the information right off the bat.
Gotcha.
If you send me an email telling me that you want a will or you're looking for a bit more information, in my response to you, you will get my process and my pricing.
Nice.
Because right off the bat, I don't want to waste your time. I don't want to waste my time. So I just want to make sure that everybody is on the same page and we understand where we're going from here.
Yep.
I offer at a base, I offer oh my God, why can't I think of I offer like structured fees. I don't charge by the hour to draft wills and powers of attorney. I offer packages for singles. I offer packages for couples. I offer different types of packages. There's a base package, and then there could be some additional fees depending on what you require in your planning.
Got it.
So, but I like to put that out there right from the get-go so that clients have an idea. And I do believe that wills, powers of attorney, estate planning in general, you need to have a connection with your professional advisors. Yep. So I will always tell clients, when clients ask me, well, is this the best price? And I offer competitive pricing.
Yeah.
I'm not the most expensive. I'm not necessarily the cheapest, but I will always recommend clients to shop around, not just for prices, but to make sure that you connect and develop, a relationship with the person that you're going to be speaking to about some really personal things.
For sure. I mean, I think that's the most important one, is that you can connect, you can understand each other. In my business too, that's what I say to people all the time too. If we don't like each other, we're not going to work well together.
No, if you feel like you can't be open, you can't be honest, or you can't ask the questions that you want to ask, or it's just at the end of the day, just not going to work out.
Yeah.
I'm telling you, I would never want to get the cheapest lawyer or accountant. Never.
You know what they say, like you get what you pay for it. And a lot of clients will ask me sometimes about these will kits, or they'll say, well, the lawyer at the end of the street is offering me, 2 wills for me and my wife for, $300. And, by all means, like, go ahead and I will not, I will not match necessarily those fees in order to obtain your business. I like I mentioned, I have a very personalized approach to these relationships, and so the time is put in, the effort is put in. I'm really looking to make sure that your intentions and wishes are reflected in these really important documents. So it's not, like I said, a one size fits all. It's not just a will that, all my clients get the same type of will. It's
right.
So sure.
Yeah.
Some lawyers charge less than me. Some
for sure. But I like that process and pricing. I like that. That's good and clear. I mean, people want to know what it's going to be up front, and they want to be able to have some comfort. That probably takes a lot of their stress out of it, that this is what happens at the end. right?
And also, yeah, and I think it takes away that stress of asking me, because
Sure. Yeah.
most people don't want to be like, they feel a little bit shy for it to be the first question, like, I want to speak to you, but am I being charged for this call, or am I
Right.
going to get a bill for this, or
Yes.
so I think it's important to determine that, from the outset, what's the relationship going to look like, and what you should be expecting as fees.
Yeah. Great. Listen, I probably got 100 more questions we can go through, but was there anything you think that comes up in meetings that we haven't really covered today that you think would be interesting, or that we should add to this?
I think that I think there's so much more that we could talk about. I think that an important discussion to maybe have next time is to talk about different scenarios. So maybe we can talk about different family dynamics, and then we can provide some comments and suggestions on based on that, blended families, first, second marriages, estranged children, adopted children, things like that. And then we can just go through different real life scenarios that hopefully everyone that's listening will relate in some way.
Yeah, I mean, that is a good idea, a great idea, and something that I think a lot of people will be looking for. I think this is a good initial, let's just put it out there information. Scott, what do you think? Do you think we covered enough stuff for this?
Yeah, definitely. I mean, it'll be great. I think it's a great idea to have Jessica back kind of as a reoccurring guest, kind of like Dr. Oz on Oprah, which Ben, that makes you Oprah.
Yeah. Subject of the month.
Exactly. No, but I think, like you said, I think that's a great overview to start with. I think it gives everybody a good sample of things they should be thinking of.
Yeah.
And I think before we do it next time, we'll reach out, let people know that you're going to be on, and we'll get some questions too from our client base.
Oh yeah, that'd be great. Yeah,
and
sure.
See what people want from there. Maybe we'll do it live too, and people could ask questions. That's another idea.
If you're up for that.
Yeah, for sure.
Yeah.
Okay, you guys want to wrap it up?
Mm-hmm.
Yeah, I think so. That was awesome. Thanks very much. You answered everything. I gave you some tough questions too, and you're very open and honest about it. So I appreciate your time so far. But I'll throw it back to Scott, and it's been nice talking with you.
Likewise. Thanks for having me.
Okay, so just one more time, where can people find you? What's your website, and how they can contact you if they want to have those discussions with you directly?
For sure. So through the website is jhoule.law.com. And my email address is jhoule@jhoulelaw.com. You can find me again on LinkedIn, Twitter, Instagram, or you can call my direct line, 613-222-5656.
Amazing. And I'll link all that stuff in the description in both the audio podcast and YouTube. Well, thanks very much again. And that's episode 6 of Think at Heart in the Bank.